Copyright is a personal property right, which allows somebody who creates an expression to stop others from taking that expression and using it as their own. As it is a personal property right, it is able to be either assigned, which means that the owner of the copyright can sell their rights to somebody else, or licensed, which means that the owner can simply allow someone else, either exclusively or non-exclusively, to exercise the same rights as the owner without giving up that ownership status. One form of license that is not found under the Copyright Act, rather in case law, is that of an implied license. As the name suggests, an implied license allows a party who is not an owner of a copyright to use that material, or it is implied from the circumstances that they should be able to do so. This particular type of license is usually only given where it's a necessity from the situation, and it's used to promote business efficacy. An illustrative example of how implied licenses work was found in the landmark case of Beck and Montana Constructions. In this case, an architect was engaged by a landowner to sketch some drawings of a building for that specific block of land. The owner then sold the block of land with the plans to somebody else. The new owner engaged a different architect who altered the original plans, but ultimately for the same purpose, and the original architect then argued that his copyright had been breached. To paraphrase Justice Jacobs' judgment, he held that the person who engaged the architect to do the designs had an implied license over that work, so long as they used it for the purpose for which it was intended, i.e. The purpose for which the architect was engaged. That is to say, if an architect is contracted to design a building for a specific block of land, it's reasonable to assume that if the owner of the land sells that land, the new owner will be able to use those plans. After all, that's entirely the purpose for which the plans were created in the first place. It's important to note that in this case and others subsequent to it, the notion of compensation was found to be important. It goes to show that even though the license wasn't written into any kind of formal contract, it's still implied that the person who engaged the creator will have a license to the work because the creator was adequately compensated. Implied licenses extend much further than architectural works. However, this specific type of material does give some great examples of how it all works practically. Another great example of the necessity aspect of an implied license is found in Robertson Candyware Limited, a case which found that there was an implied license to create garments from knitting patterns found in books. There you go, implied licenses. The main takeaway points are: a license will be implied where it's practical to assume in the circumstances that the rights would pass to somebody else. And also, the purpose of implied licenses is to promote business efficacy. Sometimes it's just not practical to have this kind of thing written into a contract, but there's really no other way around it, and it would be impractical not to give the license.